Today, we are going to be talking about the 5 mistakes that people have made in the past that can come back and haunt their green card application. These are mistakes that you should avoid at all costs. But if you already made the mistake, I'm going to talk to you about ways you can fix it. I am U.S. immigration attorney Lilian, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The first mistake people make is entering the US without inspection. This means they entered the US without a visa, without parole, without any sort of permission from the US government allowing them to come into the US. When that is the case, even if they have a US citizen spouse, even if they have a US citizen child that's over 21, they are not able to apply for a green card in the US. They have to apply for a waiver, wait for the waiver to be approved, go to an interview at the embassy, and then when they get approved at the embassy, come into the US, then they will have a green card. This is going to be a longer process. However, even though you entered without inspection, if you meet certain requirements, you may still be able to get your green card. It's just not going to be as simple as having a US citizen spouse or a US citizen child that's over 21 and applying for a green card in the US. However, you can still get a green card at the end. Another mistake that people make that comes back to haunt them is entering the US with someone else's passport, visa, green card. Right? When you enter with someone else's documentation, technically you were admitted into the US. However, there is a misrepresentation there that you need to deal with. So when you have a US citizen spouse that's filing for you, yes, technically you have an admission into the US, which qualifies you to apply for a green card. However, you will not be able to get that green card unless you qualify for a waiver and that waiver is approved. This is different from entering without inspection because the waiver you would need for this situation where you enter with someone else's green card or you enter with someone else's visa is that you will need a 601 waiver, and that waiver is filed in the US. You can get your green card in the US, but someone that entered without inspection, without any form of documentation, will need to apply for a waiver, wait for that waiver to be approved, leave the US, and then be able to get their green card once they are approved for that visa. So, entering the US with someone else's visa, green card, passport is bad. However, depending on the family member you have filing for you, you may be able to qualify for a waiver, and that waiver can be filed in the US, and you would be able to still get a green card in the US. Why did I add this to the list? Because this is a mistake I see all the time. I've had situations where people come to me after they already applied for a green card and they're denied because they had a misrepresentation, right? They entered with someone else's passport. And once you disclose that, which you do have to disclose, right? On the green card application form, it asks you, have you presented any false or misleading documents to a US immigration official? And by giving a CBP officer someone else's passport with a visa in it, pretending to be that person, or handing over a green card, pretending to be someone else, that is misleading, right? That is a misrepresentation of the facts. So you would be in a situation where you will need a waiver for that misrepresentation. The next thing that can derail your green card application process is something that can not only derail your green card application process, but it can derail your ability to file for the person. So, this is a big one. because I see this all the time. This is people not including their children in their visa applications, in their immigration applications, and then now they want to file for the child. Or they have a US citizen spouse that's filing for them and they never disclose that they had a child. They go to an interview, it comes up that there is a child, and that becomes a misrepresentation issue. And not only is that a misrepresentation issue, now, depending on when the child was born, depending on when you had the marriage, it could also lead to questions about the whether your marriage is real, right? So if you had a child during your marriage and you never disclosed that you had the child, USCIS is going to question whether your marriage is real if you're having children outside of the marriage. Now, if it was before the marriage, USCIS is going to look at whether not disclosing that you had children is material to you being able to get that green card, right? Is that misrepresentation material? Meaning, does it matter? Right? In the grand scheme of things, does it actually matter that you had these children before you got married? So it is really, really important that if you know that you have this, right? If you know you have this in your background, before you file a green card application, you should be talking to your lawyer about it so that you can have a plan before you go into the green card application process. All right. This also goes for people that don't include wives or include a fake wife in their application. All right. I'll be talking about that later. But you need to disclose this to your lawyer so that they can figure out the best way to combat this. Because you may end up needing a waiver, or it could be something that can be explained, and the officer can be okay with the explanation. So we've had cases where a child was born during the marriage, the child was not included in the application, and we were able to argue that it was not misrepresentation and it does not affect the marriage because the child was not the reason the marriage ended, and the client did not even know 100% if this child was his or not. He's never done a DNA test up until that point. So how would he know? So it's really important that you're having these conversations open with your lawyer so that we can figure out the best way to handle this. I've had cases, and this usually comes up in citizenship, where someone would not include their children on their green card application. And then when they get to the citizenship stage, they include the children. That, okay, to USCIS, that's a big red flag because as they're looking through your application, it's like, something doesn't make sense here because these children were born before the green card application was filed. Why were they not included in the green card application? Okay, so we've had situations where the person and the mother of the children were separated during a war and they didn't know that the child was born until afterwards, like years, decades after. And then we've had situations where there just wasn't a DNA test done and there was issues of whether the child was actually the client. So in those situations, USCIS officer can make a determination of whether to find that to be a fraud or to just say, well, if you don't know that's your child, how can you put them on the application, right? Because if you put a child that's not yours on the application, that's also a misrepresentation, right? So, however, that only works for fathers if you think about it, because a father can say, I didn't know that I had this child, but a mother can never say that, right? Because you carried the child, you gave birth to the child. How are you telling USCIS that you didn't know? So the I didn't know I had a child, right? If that's truly the case, only a father can actually use that. So for mothers that are in these situations, the question becomes whether the child not being disclosed, whether that was material to the application. Okay. If it's not material to the application, then the officer may still approve it without a waiver. If it was material, the officer may request a waiver before you would then be able to apply for a green card and have your before you be able to have your green card approved. Another flip on this is that not only can it affect your ability to get a green card, it can also affect your ability to give a green card to your child. Because if you never said, "This is my child," and now you're applying for a green card for that child, USCIS is going to have questions. So you better have good answers for why that child was never included. Like I said, with mothers, it's going to be a lot harder for you to make those arguments. However, for fathers, depending on the actual situation that you are in, if you did not know you had a child or there was disputes about the paternity, it wasn't, you weren't married to the mother at the time and you weren't sure if the child was yours, arguments can be made there. So you would still be able to file for the child. USCIS will most likely request a DNA test to be done. And as long as that test comes out positive that it is your child, again, it depends on a lot of different things. But if the only issue there is whether they're your child or not, then you can still file for them. But it's really important that you list your children on your applications, because not only can it come back and bite you, but it can also come back and bite your child. By the way, if you are getting value out of this video, please do not forget to like this video. The next mistake that people make that ends up costing them their green card or derailing the green card process is presenting fake documents. I have seen fake marriage certificates, fake bank statements, fake work documents for visa purposes, fake birth certificates, marriage certificates, divorce certificates. I have seen all of those. So how does this actually affect the green card process? If you are getting a green card through marriage and you were previously married, you're supposed to have a divorce document. If the divorce document is fake, then your current marriage is not valid, right? You are not legally married, because you cannot be legally married to two people at the same time in the US. So, what happens here is, if you are in this situation and you want to divorce and get married to someone else, that's fine. Make sure that you go through the proper procedure of actually getting a divorce. If you live in the US, you can get a divorce in the US from someone that does not live in the US. Okay? It's possible. So go that route. Do not present fake documentation to USCIS or to the embassy. So there may be arguments to be made that the false document may not be material to the case. However, presenting a false document, period, is a problem, and USCIS most likely will require you to present a waiver. When you present a false document and USCIS wants you to file a waiver, you'll file a 601 waiver in the US. You can still get the green card in the US. However, you still have to qualify for the waiver. You really want to avoid having to do that. So make sure that whatever document that you're presenting to USCIS, to the embassy, that they are accurate and from the right place. The next thing that can derail your application or your ability to apply for a green card is fake marriages. Okay, so I'm going to do this in two parts, right? Put in a fake marriage in your visa application. So the first way this shows up is when people are applying for a B1, B2 visa, and they think that by putting in that they are married, even when they're not, that's going to make them look better to the officer at the embassy. So they put in a fake marriage, they put a fake name, fake date of birth, everything in there. And they go to the interview, the officer asks them about the marriage, they say, yes, I'm married, and blah, blah, blah. They get the visa, they come to the US. Now they actually marry someone, and this is legitimately their first marriage. However, they have the marriage that they put on their B1, B2 visa. So now the officer is going to be looking in the file and looking for a divorce decree for that first marriage. Because now, to the officer looking at your file, this is your second marriage, not your first. Because you already told them that you were married. So you're going to be looking for a divorce decree. If there's no divorce decree, then why did you tell them that you were married before? Right? So they really want to understand, right? Like USCIS officers at the end of the day are people. Like they get confused too. Why is this saying that it's their first marriage if we know from their previous application that they've been married before? So, how do you fix this? So, if you're in a situation where you applied for a B1, B2 visa, you put that you were married when you weren't actually married, now you are truly married to a US citizen, you will need a waiver. You will need to prove that you were never married. It's really hard to prove a negative, right? It's hard to prove that something never happened. It's easier to prove that something happened because there will be documentation. But some countries have basically an affidavit of non-marriage, like saying that the person has never been married in any place in that country. So that's a good document to use to show that you were never previously married. Affidavits from family is another good one that you can use to show that you're not married before. But remember, you will still need a waiver because you did lie on that application to get an immigration benefit. Okay, when you lie on an application to get an immigration benefit, that's misrepresentation, and you will need a waiver for that misrepresentation. So that's one way when people put a fake person as their spouse on their application. Another way that this comes up is when people pay someone to marry them. This is the worst, the worst, the worst. Because if USCIS finds that that marriage is fake, right? If they have evidence to prove that that marriage is fake, they can not only deny the green card application for that specific marriage, but all future marriage applications, all future green card applications are out the window as well. So think about that. So if there's ever a 204C finding, that's the marriage fraud finding. And if that's ever attached to your file saying that this person entered into a fake marriage for green card purposes, for immigration purposes, that means even if you get a 21-year-old child that's able to file for you that's a US citizen, they can't because you have a 204C finding. And there's no waiver for that. Right? So some officers are nice and they will say, oh, you had a misrepresentation. There is a waiver for misrepresentation, but there's no waiver for marriage fraud. Let's be clear on that. There is no waiver for marriage fraud. So whenever the officer realizes, oh, this is not a real marriage, and they put that 204C on your application, you're stuck. Okay? You won't be able to get a green card. And let's say you withdraw the application before the 204C finding, the next officer may still um, get a 204C finding. So it's really important that you not enter into a fake marriage because that is the fastest way to make yourself ineligible for a green card. Okay, if you want to make yourself ineligible for a green card, go ahead and enter into a fake marriage and let USCIS find out because they will make sure that you do not get a green card. So, one of the hardest things to fight is a 204C finding. A marriage fraud finding is very hard to fight. We've done it in my office. We've gotten an application approved after the officers thought that the marriage was fake. However, it is hard. I am not going to lie to you. Y'all know I don't lie to you here. I tell you how it is. It is hard to beat a fake marriage finding. It's not impossible, but it is hard. And it affects so many things. It affects your ability to get a green card in the future. So really, don't do it because it will affect you. Okay. And just to recap, the 5 mistakes that can come back and haunt you in your green card process is: number one, entering without inspection; number two, entering with someone else's visa or green card; number three, not including your children in your visa application, your green card application, your citizenship application, right? Um, Giving fake documents to US immigration officials; and finally, entering into a fake marriage or putting a fake person as your spouse on your application to get a visa to the US. Those are the 5 things that can derail your case, and you want to avoid all of these. However, if you're in a situation where you already are in this, right? You already have one of these things in play and you want to know how can you move forward. Like I said, there's options for most of these. Marriage fraud may be there may be an option for that depending on what you can prove about your relationship, right? If you can prove that your marriage was actually real and the officer was wrong, you can fight that finding. So if you are in a situation where one of these applies to you and you want to know what can you actually do in your particular situation based on your facts, what are available to you, go ahead and schedule a strategy session with me. You can do that by going to my website, lillylegal.com, or calling my office at 508-443-1788. By scheduling the strategy session, you can at least get a path forward. You'll know what is available to you, what you can and can't do, and we can see how we can help you get to that green card.